Yeah, that's fine.
Okay. We've still got a couple people joining.
I mean, we can. Okay.
Up to you. We are ready to go when you are, so I can still keep admitting people while you get started.
Sure. Yeah, it's not for credit, so you can, timing's not that sensitive. All right. Well, good morning, everybody. Thanks for joining us. We are going to talk about title essentials and kind of what happens once you bring a contract to us. What's it take to get from that contract to bringing it all the way to funding? Let's see. So Nicole, if you'll go to the next slide for me. One back. There you go. All right. So what you've got in front of you is just a general process overview. And this is very top level, not getting into all the details. We'll get into those as we go, but it shows you what happens when your contract comes into us, and it shows us and then the mortgage company, because each group does something slightly different. So on our end, we receive the contract, we open our order internally, and opening that order internally is what starts all of the research that we do to get to closing. Okay, Ray says can't hear anything.
I am able to hear you just fine. Ray, did you test your microphone when you got on and test the sound? Anybody else having issues?
No, I can hear.
Okay. Ray, you may want to hang up and dial back in. Sometimes that will clear the issue.
Okay, so once we open the order, we have two different departments that start their research. One department is our tax company. So that's where they go to pull their research to find that specific property, find out if the taxes are paid, find out what the taxes were last year and what sort of exemptions apply to that piece of property. And with that information, we produce the tax certificate. The other department that's working right now is called our exam department, which for us is a bunch of people that we've worked with for a really long time. They're all local. All of them have actually worked with me for a long time, and they're our research brains. So they're the ones that look at the individual property to see who owns it, what kind of liens do they have that have to be paid, what kind of encumbrances are on the property. And we'll talk in detail about what encumbrances are. Exam does their research to produce the title commitment, and then the title commitment is sort of our map to get to closing. On the other side, once our contract's been sent out to everybody, the lender's also working on their side, and the lender's working to get the buyer prepared for closing. That's where they go through the loan application process. That's where they look at the credit worthiness of the borrower, income, assets. They also do the appraisals at that point, collect all that data. That data goes to their local underwriter, and the underwriter then hopefully approves the loan and gets us ready to closing. All of that sounds like a pretty short process. It's actually a lot of detail. And so we're going to talk more about what happens to get us to actual closing. But first, we're going to talk about the title commitment. So for my realtors on the call that don't typically look at your title commitment, that's okay. I think most don't. But there are some pitfalls for it. There are some concerns that create liability for you. And so I want you to understand the important things I think you should be looking at. Nicole, can we go next slide? Perfect. All right, so we talked about how a title commitment is created, and that's through our search department. The different resources that we look at, we do the official public records, which is actually back in the day, you used to have to go down to the county and piece all the documents together. Everything is digitized now. So we run a chain of title on that specific property, and that'll tell us all the conveyances that have happened in the back chain. That same chain of title will tell us if there are easements on the property, if there are building lines, if there are any liens. We also do what's called a name search. So with a name search, we go out and we look for judgments against the seller. We look for bankruptcies, pending foreclosures, anything that might be filed in the district court. And so pulling all that information together, if it's not a complex exam, can take anywhere from 3 to 5 days. If it's a more complex exam, maybe if it's not in one of our counties, or if we've got somebody that has had a divorce, there's been a bankruptcy, there's been a really convoluted probate, that's when you might see your files start to take a little bit longer because we have to go out and find additional records. What's on your screen right now is called the jacket. So that's the first page of the title commitment. that's going to tell you who the underwriter is. So when you go to closing, we are your escrow company. Texas National Title is the group that takes in all the money from the buyers, gives the money to the seller, pays off the liens, and then transfers title to your purchaser. That's your title company, which is also known as your escrow company. Where we get the authority to produce the title commitment and the ultimate title policy from actually comes from the underwriter. And so in the example that you've got right there, your underwriter would be Title Resources Guarantee Company. They're the ones that basically make the insurance policy to the purchaser or to the lender. We can go to the next slide. So we're going to talk about a title commitment in detail, but what I want you guys to understand is that Schedule A basically says these are the items we're going to insure. Schedule B says these are the items that are not covered in your title policy. And then Schedule C says this is the list of requirements that you have to do in order to get to closing. Schedule D is promulgated disclosures from the state, so not really important to you guys as realtors on the call. Next slide, please. All right, so let's talk about Schedule A, because I think, when you go to realtor school and you start practicing, nobody really talks about what the title commitment does. And it actually is a really important disclosure for your purchaser. What the title commitment says to the buyer is this is all the research. This is the list of easements, the list of building lines, the list of liens on the property. This is all the things that you can't really see when you look at a property. So we place a lot of value on the inspection of a home. And that's for the same purpose, which is to find things that you can't see when you're wandering around the property that might be latent, that might be a defect that would keep the purchaser from wanting to buy the property. The title commitment is that same function for the research and the records, basically. So when you're looking at a title commitment, there are a couple of things that you should be checking, whether you're on the buyer or the seller side. When we look up top there, the effective date, September 7th of 2017, that's the last date through which we could get research from the county. And so you'll commonly see a gap between the effective date and then the issued date. And that's because the county runs 8 to 10 days behind on getting in all their documents and posting it. So when you see that gap, that's why. When you're looking at Schedule A number 1, this is the section of the title commitment that talks about what policies are actually going to be issued to your purchaser. So if you're representing the buyer, you want to make sure that your buyer's name and sales price is shown in either 1A or 1B. In your typical residential transactions, you're going to see it in 1B because that's a residential policy, basically. Item 3. So item 3 is super important because it's going to show you who we think your sellers are in that transaction. There's a whole lot of ways that you guys can accidentally be led down the path of having an incorrect seller listed. A couple good examples. So let's say that you're dealing with Jane and Jane's husband is deceased. Most of the time, people operate under this, I guess, premise that property acquired during a marriage is community property. So more often than not, we run into a scenario where Jane has been working with you, Jane signed the listing agreement, Jane has signed the contract, and then we open title and we find out through the records that Jane and John were married and John is now deceased. If John has only kids with Jane, then that property does pass under community property law and Jane would be the sole owner. But if John had any other child outside of that marriage or from a previous marriage, then the law says is that Jane keeps her 50% ownership, have the 50% own. You guys don't know this. You don't really have the opportunity to discover it. And your client's not nefariously leading you into a fraudulent path. They don't understand it either. Jane's going to think she's the sole owner of the property. We're the first ones to tell you this. By the way, there are 3 other kids in title. So at this point, you don't actually even legally have a contract anymore because all parties that are required to sell haven't participated in your sale, in your contract. And the very first opportunity that you're going to have to disclose that or to find out that information is going to be on Schedule A, Item 3, when the title commitment comes out. So as an agent, if you're not in the habit of looking at your commitment when it comes out for Schedule A items, you want to make sure that you're looking at A3 because that's the first chance you're going to know that there might be a problem. There's a lot of liability that deals with that applies to agents right here, because we typically have made the statement at this point to the buyers and the sellers that we are under contract. And so you have to be really careful to go back and unravel that statement that you've made, because you're really not under contract at this point. So you always want to check Schedule A, Item 3. This is where you'll find out about probate problems, divorce problems, bankruptcies. I've had a couple of files lately come out where an agent has gone through all the trouble of doing a listing and getting under contract, only to find out that the client had filed bankruptcy. And in many cases, when the clients filed bankruptcy, they no longer have the legal authority to sell on their own without court intervention. And so it's basically been a waste of time for that agent, because if the court doesn't approve that sale, you've done all that due diligence. So always look at that, because that's your first opportunity to know that you're going to have a problem. Next thing that you should look at is Schedule A, Item number 4, and this is where you should be checking the legal description. So with legal descriptions, it's a bit of a challenge for the title company, because this is very much a garbage in, garbage out type situation. So if the contract that comes to us has incorrect information in it, that contract is an instruction to the title company for which property to examine. And that's the property that we're going to do the research on, because we don't have all of the knowledge of what's been actually happening through the negotiations and the communications from buyer to seller. So things to be careful for. We had a real life example before where the contract said that the property that was to convey was lot 6. And so we examined lot 6 and we closed lot 6. And what we found out post-closing is that the intent of the parties had been to convey lot 6, but also convey a portion of lot 7. And the portion of lot 7 that was not a part of the transaction because it wasn't septic to the house. About why wasn't the septic included? And the answer is because it didn't get written into the contract. So when that commitment comes out, that's your first opportunity as an agent to look at the legal description and say, oh, wait a minute, we're missing something. I want you guys to think about the title commitment, especially with the legal description, as our report back to you of this is what we're going to close. And if anything's different, you guys want to make sure that you point it out to us. We have had scenarios before where a seller may have had multiple properties down the same street, and the contract was written for lot 26, but everybody standing on the street really meant lot 25. And if we get a contract that says lot 26, that's what's going to be sold, because we're not part of those negotiations. So it's important that you guys look at this. Another thing that pops up with legal description can fall into play with acreage issues. So if you're primarily a residential realtor and you're starting to dabble in acreage, I really can't stress enough how important it is that you work with your broker, because with acreage, there are a lot of other nuances that come up that don't present themselves in your standard residential transaction. And particularly defining the legal description can be one of those items. With the legal description and an acreage tract, it's not as simple as just referencing a plat. You actually have to have a separate document called meets and bounds that attaches to the survey. And that meets and bounds is the legal description. So if there's any kind of defect in that, or if your client has a large tract and they're trying to convey out little tracts, that's a place where you can have a lot of liability. So you want to watch out for that. Fourth issue I have up there are the new condos. So it has been incredibly popular lately for somebody to take a platted subdivision lot that has one house on it, and they want to carve it out and now put a second dwelling on it and sell those 2 units to different people. So when we think about a legal description, think of that as the property's name. And when we track the conveyances over the years, we track it by name. So when I say a property is lot 6, block A, that is that legal description. That's that property's name. And as we sell, we share that name through all the legal documents to track it. So once a piece of property is dedicated with that lot 6, block A, that is its name forever until there are additional legal documents that are filed. And in order to create those condo regimes, in order to create 1 unit now into 2 to be sold, there are condominium declarations that have to be filed. What I'm seeing probably 9 times out of 10 is that when you're on the listing side, your client hasn't filed the paperwork yet, files paperwork that is incomplete, or doesn't have legal counsel. And so the documents that they're filing don't actually change that name. They don't legally create the two separate units. And so in MLS, and you'll see this all the time, you'll see unit 101, but the legal description is lot 6, block A. That means your listing has not actually formally dedicated the two separate units. So think about this from a buyer's agent perspective. When you're writing a contract, if you use the legal description lot 6, block A, aren't you then saying your client's purchasing that entire tract? Under the law, you are, and that's a great deal for the buyer, but that's a terrible deal for the seller. And so when you have that ambiguity, it is something that creates legal liability for the agents. So you want to be very careful that you're properly describing in your contracts what lot is actually being purchased or which tract. And the way that you can do that is to make sure you're calling it proposed unit 101, put something in special provisions that says the seller has to file their condominium declarations prior to closing, something so that you're making it unequivocally clear what the parties are really intending to convey. Can I have the next slide, please? All right, so of the title commitment, Schedule A is how we're going to insure the transaction. Schedule B now is what we call our exceptions to coverage. So exceptions are things that are not covered under your standard title policy. Most of these come from state law, and basically the Texas Department of Insurance has said these are things we would not cover in any kind of policy. I call those promulgated exceptions. Then we have the transaction-specific exceptions. Those are the documents that have been filed that affect the tract of land that your client is purchasing or selling. Transaction-specific exception 10. So in the example in front, one says the following restrictive covenants are itemized below. All those hyperlinks are individual documents that have been filed back in the chain of title, so prior to our closing, that affect the property. It's very normal to see things here. If you're in a platted subdivision, you should see the plat because we can't have created that lot without having the plat. This is where you'll find homeowners association documents. This is where you'll find easements of record, basically anything that says the property has been established and these are rights or interests that other parties have in them. So something like a building line, you've seen this a lot on your surveys. There's a 5-foot building line, means you can't put anything within 5 feet of the property line. So when you're looking at these items, this is a positive. Where it's a positive is given to the buyers so that your buyers can do their own due diligence in purchasing the property. That's really important for you guys to protect your liability because your buyers ask you questions like, can I paint my front door red? Could I put an accessory dwelling unit on this property? And a mistake that I see agents make is they'll say, okay, I want to find out, is an accessory dwelling unit available? I'll go down and check the zoning. And maybe it's permitted by zoning. But then we forget to do the second step, which is to look at these restrictions because it might be prohibited under the real property records. Always gives me the willies. I think it's better for you to say, look at your title commitment. You need to check zoning and you also need to check the commitment. It actually gives them a copy of every single document that affects this particular tract of land. So instead of you guys being the experts, you're giving them the resource of where they need to go. And ultimately, if they have those kinds of questions about how those documents legally affect their purchase, they need to go to an attorney because it's the attorney who can actually say, this is permitted, that would not be permitted, and give them advice about their interests. So it's a great way for you to shift the liability from you as the agent back to the buyer to say, this is a report that helps you do your due diligence. You have to look at it and make those decisions. Can I have the next slide, please? All right, so let's talk about area and boundary coverage. I don't know how many of you guys on the call are super comfortable explaining it to your customers, but I also don't think you have to be because really this is our job as the title company. It's our job to explain to your client what this does for them. But I want you to think about that client that you've had where you're standing in the street and you're looking at a piece of property and they're slowly falling in love with it. And they ask you this question, is that my fence or the neighbor's? I'm sure every one of you can say that you've been asked that question. The reason that's important is because buyers want to know exactly where the boundary lines are of their property. And something that's important for you guys to know is that your standard title policy that's issued offers your purchaser zero coverage for that matter at all. So the standard title policy that's issued does not insure any issues related to the boundary line of the property. So if your client immediately runs into a fight with the neighbor about where the fence should be, that is not covered under the title policy. If post-closing your client finds out that there's an encroachment of a shed that's onto the neighbor's property or from the neighbor's property into theirs, not covered by the title policy. And that's a big risk for you guys as agents, because when you're filling out the contract and you're checking the box that says the coverage will or will not be amended, that's a teeny tiny little detail of the transaction that is not important to your buyers on the way in. What's important to your buyers on the way in is sales price, closing date, hopefully us as your title company, things like that. That little detail, not important to them, because everybody assumes that the title policy they get from closing covers these issues. So what I have on the screen there for you is Schedule B, Item 2. The top section there, that is what the exception reads like all the time. So an exception to coverage means if post-closing your client has a discrepancy in the location of the boundary line, a conflict with their neighbor, shortages in area, meaning the survey said it was 0.4, but they thought it was 0.45, encroachments, which are things from our lot into the neighbor's lot, or protrusions, which are things from the neighbor's lot into ours. Any of those issues pop up post-closing, they cannot call the title company for any protection because it's not part of the coverage. When we say we'll give you area and boundary coverage, or we'll give you survey deletion, what we're saying is that we then take that policy and make it show what is in your second box there. So where I've taken Item 2 and I've literally drawn a line through everything except shortages in area. The legal effect of that is instead of taking the exceptions we were going to take up top, we've now added that coverage in. So now if your client has a fight with the neighbor about where the boundary line is, has a fight about an encroachment, instead of your client having to go out and hire their own lawyer and pay $300 to $500 an hour to litigate that issue, they come back, they file a claim under the title policy, we hire the lawyers, we litigate the issue. And that's a really important thing for you guys. And this happens to us several times a year. We'll run into a situation where maybe the survey had an error in it and your client could have benefited from the coverage, but they didn't get it because the contract didn't say to have it. They call us, we pull their commitment, we say, you didn't pay for the coverage, so you don't have that coverage. And then the very next phone call is to who? It's always to you guys because you sold them the house. And for us and also for you, they have consumerism on their side. So as a consumer, they can say, I didn't know about this, and the title company didn't tell me, and the realtor didn't tell me. And of course, I would have purchased it had I known. You guys can all think about somebody sitting up there in a deposition talking about why this shouldn't be their problem to litigate. So it's really important for you guys as agents. I say you always tell the clients to get the coverage, and then later if they want to decline it, that's fine. We have them on record doing it. But I never want an agent saying you don't want that coverage, because you're basically playing fast and loose with your own checkbook at that point. The coverage is not issued until closing. We do have to have an acceptable survey. If we're using an existing survey, we have to have a T47 for it. And then of course they have to pay the premium. The premium on this, guys, is so small. It's not one of those things where it's just fee generation for the title company. It's real coverage and it's very important for your clients. And on your standard residential transaction, it's only 5% of the owner's title policy. So if you've got a $500,000 transaction, that's about $125. So basically for $125, your client can protect themselves and they could never hire an attorney for that much. So it's something where as agents, I always want you guys to say that it's important for them to have it. Next slide, please. Here's a couple of examples of places where it would protect your client. I've kind of talked through these, but think about in your brain that area and boundary coverage protects your client when there is a fight about something on the boundary lines of the property. That's where it's going to kick in and protect them. It can be as simple as fences. Many times your clients fall in love with the house, but they think they're going to replace the fence. Those two neighbors, the seller and the neighbor, have lived in perfect harmony for 15 years. But as soon as your client buys it, moves in, and wants to do something with the fence, now all of a sudden there's a fight about where it should be. That fight is covered by the title policy if they get the coverage. Otherwise, your clients are 100% on their own to pay for this. Next slide, please. I've given you an example of a minor, tiny little thing that speaks to the area and boundary coverage. So I've highlighted that fence line along the right side of the property there. So that fence line sits about 5 feet into the neighbor's property. Might not be a big deal, but it might be a really big deal if those neighbors get crosswise with each other. So there's always an argument at this point, is that my fence? Is it the neighbor's fence? With this type of scenario, you'll run into people thinking that they own that little tract of land because they've fenced it in. So there's a lot of disputes that can come from that. And you have to look at it and say, do I want my client to have protection, or should my client be on their own to litigate this issue? That's what area and boundary does. Next slide, please. All right, so let's talk about the rest of Schedule B. The rest of Schedule B, most of the language between, let's say, 3 and 9 is promulgated language that's set by the state. That language is not going to change. It doesn't even apply to every policy. So at the end of each exception, there's a parenthetical that says which policy it applies to. But those are things that you're never going to be able to change. Ironically, we get a lot of objection letters where people object to all those items, but you can't. Starting with item B10, now we're back to individual exceptions that do affect your property. So this is, again, buyer due diligence. And this is where I want you guys to have a standard email that you send out to the buyers when the commitment comes out. What buyers tend to do when they get themselves in trouble is start to look for where they can place blame. And we're an easy target and you guys are an easy target. What they say is, my agent didn't tell me that it is so important that I look at this. I just thought it was paperwork for closing. So if you have a standard email, when the commitment comes out, we send it to your buyer, we copy you. I want you just to reply and say, hey, as a reminder, this is one of those important documents we talked about. It's a due diligence package for you for how your interest in the property would be affected. Please make sure you review it. That's enough for you guys as agents to shift that liability to the buyer. Because then if the buyer goes forward, let's look at item 10.4 there. So there's a pipeline easement for the gas company. That pipeline easement has existed for quite a while, I can tell you, because the recording information is very old. That easement today might be fine, but if your buyer wants to tear down the house and build a bigger house, maybe now that easement keeps them from doing that. And they're not going to find out until they're very far into the process. They might not even find out until after demo is over. They're going to come back and say, wait a minute, you didn't tell me that I couldn't do blah, blah, blah with my house. The commitment's going to say, actually, we did. And we provided a copy of the document to you. And now it's your responsibility as the buyer to make sure that this property is suitable for your intent. You as agents want to be able to shift that same liability to the customer, because you don't know what the customers do post-closing with it, and you don't want to be legally responsible for it. All right, next slide, please. So as an agent, Schedule C is also important to you, whether you're on the listing or the buying side. Schedule C is going to tell you if you have any problems getting to closing, basically. What I have there for you is a very clean Schedule C. So those items 1 through 4, you'll see on every single commitment. Starting with 5 is where you'll see the transaction-specific requirements. Here you just have a deed of trust, which means we order a payoff statement and we're good to go. If you see things like bankruptcy, requirements for correcting documents, federal tax liens, divorces, probates, those are all things where we're saying before we can close, we have to solve these riddles. And that can take a very long time. So as an agent, this is your first opportunity to realize that you might have a delay in closing, and you might actually need to start working on an amendment right away. When you see those items, every single situation is different. And so I don't think you guys need to be the experts, but I think you need to have it as a red flag to know that that's your time to pick up the phone and call your TNT closing officer and say, okay, what do we have to do? All of my guys are super, super knowledgeable about this, and they'll be able to tell you, I see this issue all the time and here's what we do with it. Or they might say, I've never seen this before. I need to talk to my attorney. That's when they come to me and I help them navigate what we need to do with that file. But that's your first opportunity to know if you're going to hit closing on time or not. And so it's a really good thing for you to always look at Schedule C and say, what are my issues going to be? Hopefully they all look like this. If they don't look like this, we can help you figure out what has to happen. Many times where we get to is a point where we say, this is what has to happen, but we can't fix it. So if your seller's involved in a guardianship, that's a process by which there has to be court intervention. They have to hire an attorney, and it's not a quick process. So we can get to a point, and then we have to tell the parties what they need to do. Next slide, please. All right, so you see we just covered a whole lot of stuff in what looks like a little bitty window. It looks pretty simple getting to this point, but this is kind of where the magic happens. So now the commitment is out. We send it to the buyer, we send it to the seller side, we send it to the lender, and then there's a gap in time between that date and getting to closing. There's a whole lot of stuff that has to happen in that section. So next slide, please. So this is what your closing teams are doing. And I would say to you guys that it is super important that you work with a closing team that operates from a proactive standard. Proactive is when the commitment comes out, my guys start working that file right away because they want to watch out for any pitfalls that might be coming. Some companies subscribe to, we'll wait until 2 weeks prior to closing and then start working on it, and that's the wrong method to use. Let's get everything crossed off the list so that if we have a problem, we have time to deal with it, is our mentality. Something that we're doing here at this point is we're doing wire fraud warnings to your buyers. Wire fraud has ramped up substantially, especially with COVID. But over the last several years, your buyers are under attack because fraudsters are trying to get them to send their money to their account instead of ours, basically. So we actually call every single buyer and talk to them about wire fraud. It's super important if you guys will fill in your buyer information in paragraph 21. That's where we call from. So please give us that. But we want to talk to the buyers about what wire fraud looks like, warn them about when they should and should not send their money, and help protect their funds for closing. The other things we're going to talk to them about, we need to find out who their mortgage company is going to be. We also need to talk to them about picking a home warranty company and a coverage plan. And this is a place where you guys can help us a lot. We are almost always tracking down the home warranty company the day before closing. And that's okay because we can get it done, but sometimes it changes the closing statement. And if it changes the closing statement, then the buyer has to go back through the process with the lender sometimes. So you want to make sure you're helping us get that home warranty company picked before closing. We're also asking them about their closing details. Are they going to be coming to closing? Are we doing a mail out because they're not local? Do we have a power of attorney? Power of attorneys, closing into a trust, closing into a corporate entity. Those are all things that have additional steps. And so we need to know in advance if we're going to jump through those hurdles or not, or jump through those hoops. Next slide, please. On the seller side, we have a lot more stuff we need to do on the seller side. So with the sellers, we are talking to them to get their payoff information because we need to order the payoff prior to closing. As far as ordering the payoff is concerned, all of our closing teams know the lenders and how long each lender takes. Some lenders, it's super fast. We can get it the same day. Other lenders might take 15 days. And so it's important that your clients are giving us this information up front. We need to get their social security number so we can order the payoff and also do an ID check on our end. We need to know their marital status because if they are married, we have to get something from the spouse in most cases. We're asking them for the survey and the T-47 affidavit. All the items above, the payoff lender, the social, and the marital status, we send out a DocuSign seller questionnaire the day the contract comes in, and that will go to the client. It actually reminds your clients every single day for 10 days until they send it back to us, and we still have files where we're having to track them down. So something that you can really help us with get closer to closing is to say to your clients, when the title company sends something out to you guys, fill it out and send it back. Y'all have this relationship that you've built with your buyers and your sellers for weeks and sometimes months before you get under contract. So they trust you and they do what you say. We get them and it's sort of a mad dash to closing. And so they just don't always listen to us as well as they listen to you guys. So help us out on that, please. We're also going to ask the seller what their details are for coming to closing. Are we doing a mail out? Will we have a power of attorney? If there's anything in the chain of title that we need to work on, like trust documents or probate issues, we'll work with them on that. We do work with the sellers about handling their judgments and working with the IRS to obtain a payoff. Those two issues there, many times, those are very time-consuming processes that have to get done, and it's completely outside of our control. Good example is right now. Right now, the IRS is closed, and they are not responding to any inquiries that we make for a payoff statement. So if we're going to have that kind of problem getting to closing, my team needs to know about it really early on so that we can see if there's an alternate of what we could do, see if there's another route that we could go. So the more your sellers work with us on these items, the easier and smoother your transaction is going to be. Next slide, please. All right, here's what we need from you guys. So I think it's a good rule of thumb to start working on your disbursement authorizations once the commitment comes out. We also want to confirm those commission amounts with you. We presume it's 3% on both sides, but if you've worked a different deal, we need to know about it so that we can do your statements correctly. We also need copies of any amendments that you do. I can't tell you how many closings get held up because we come to closing and we're the last people to find out that there's an amendment that's been done. So when you're doing an amendment, even if you think it's not something that affects title, please send those to us because we need to make sure that we're tying those knots very tight in our transaction. And if you have any special details about your clients, you know, they like to read everything, so we know we need to schedule a longer closing. They're in the middle of a divorce and maybe there's going to be some tension. If there's a language barrier or if someone's hearing impaired, let us know all those things because we can absolutely handle it. But there might be some timing issues that we need to work on. There might be special exceptions we need to make for them. And I won't know that unless you're telling your closing team about that. Next slide, please. All right, so commitments out. What is my closing team doing right now? They are ordering the home warranties. They're ordering the HOA documents and sending those out to customers, working on getting the payoffs. We're looking at a survey if it's been given to us, or we're ordering a new one if if the contract says that. We go out to the lender and we say, here's your commitment. Now what we need from you is we need your closing instructions and all your loan documents. The closing disclosure that's actually produced at closing, it's a relationship between us and the lender because the lender has half of the data. The lender has about 25% of the data. We have the other 75% of the data. So we have to get together to get that CD. We're setting closings with all parties. And right now, setting closing with all parties is taking longer because we're trying to do as much social distancing as possible. I'm trying to keep the foot traffic in my offices to a minimum to protect our employees as well as your clients. So traditionally, we would say, here's the time on the calendar, everybody come in. Now we're having to call and say, will you come to curbside? Are we doing it electronically? So there's a bunch of different things and it takes longer right now. We're making arrangements for the actual signing for everybody. And we're working with the lender to get their 25% of the figures that they have for the closing disclosure to match our whole picture so that we can get that closing disclosure to your client. Next slide, please. So a couple of questions usually come up here. First one is, why does my buyer get a CD from the lender before we have one ready? So the lenders have a legal obligation to send out a closing disclosure 3 days prior to closing. So most of them send their best guess on what they have out to the customer so that they can fulfill that requirement. Once that first initial one goes out, then they start working with us to tweak the fees. Typically lenders don't have things like homeowners association dues. They don't always know what our premiums are going to be. They don't know your commissions. So there's a lot of data that we have to give to them. That's also why your buyer might get so many versions of the CD. The lender puts theirs out first. Then we do what we call balancing. So we get together and we finally get to where they match 100%. That process can take a little bit of time depending on how that lender communicates with us and how much information they have ready to go. That's also why they can be so last minute. Sometimes the lenders send out their first initial disclosure 3 days prior. We don't actually get all of our closing documents or our CD until the morning of closing, and that's when we start balancing. So that's kind of why the target moves on timing. Next question comes up is, once we have a final CD, why can't we just go to closing then? Typically, we get a package of instructions, we balance our CD, we get to where the lender's on the same page as us, and then they'll send us the loan package. So there's just a time delay between getting that CD and being ready to actually go to closing. We're waiting on that big stack of documents that your customer signs at closing. Next slide, please. All right, so good tips for you guys as real estate agents. Be cognizant of heavy closing days. So it used to only be the last day of the month, and boy, that has changed. Now our busy closing days are every single Friday, the 15th, and then kind of that last week of the month because everybody wants to get moved in. So when you're writing your contracts, you're gonna have people that absolutely need those dates and do those dates, but you're also gonna have people that are much more flexible. So you can pick dates that don't necessarily coincide with those. Also, it's important to think about what time of day your clients are going to close. If they schedule and sign in the morning, then you have a really good chance that your transaction is going to fund that day. But if you have your buyer sign at 4 o'clock, it's probably not going to fund, meaning they can't get keys that day. And we'll talk about what happens after for funding. But there's a whole process that happens after people sign. So if you sign in the morning, your chances of funding are good. If you sign later in the day, it's going to be harder to get it funded in that same day. I mentioned earlier having all amendments provided to us. That's super important. And then these are the reminders that you can really help us have a smooth closing for your client. If you remind them to come on time, bring their ID, and it be a current one. At least once a week, someone shows up to closing and says, oh, my driver's license is expired. So helping us with those reminders are really good. Also, have your clients have their money ready for closing. If they come to closing and they sign and then they go to the bank, it's okay. But what it means is that they are delaying the funding process because we have to have all the documents and all the money before we can get to funding. So if they sign the documents and take an hour to do that, and then go to the bank and then have lunch and then bring their check back, you can see how they're delaying that funding process because we're just in a holding pattern waiting on them. Also for your seller clients, ask them to bring their wiring instructions to closing. I really don't want your sellers emailing us wiring instructions. That's pretty much like just dropping your checkbook in the parking lot and hoping somebody doesn't look at it these days. So they should bring those instructions to closing. All right, next slide. Okay, so now everybody's signed. What do? I've got funding circled there because funding is a process that has to happen. Next slide, please. So what happens with funding is we get all of the signatures from the buyers, we get all of the signatures from the seller, and we have to package it up and email it over to the lender. The lender then goes through and checks things that are important to them, and they provide us with the funding authorization. Some lenders do this at the closing table. Some lenders don't even require the package back and they just give us approval to fund based on us getting the document signed. Other lenders want to review that whole package. And so if they review that whole package, there's a timing component to that. Once we have funding authorization, we then have to make sure we have money from all the parties, which is the buyer, the lender, occasionally the seller, and we have approval from everybody to fund. That whole little package, we love to wrap up and put a bow on it. Sometimes it can take an hour, sometimes it can take all day long, and it just depends on the moving parts, which would be your buyers, when they sign, how they bring their money, and the lender giving us approvals. So as agents, you guys kind of have to have a plan for the key release upon funding. It's definitely our priority to fund as quickly as possible, and everybody kind of turns on the jet thrusters as soon as we have what we need for funding. But it's something where we're often left with, we're closing and funding, maybe everybody's signing at 3 o'clock. We don't fund today, we're gonna fund tomorrow, or Monday in this case, and your buyer wants to know what's going on with the keys. Keys are not really something that's a title company function or a title company responsibility. It's something that y'all have to handle outside of closing. So you have to be sensitive to the timing issues that you might have about how you would pass those keys back and forth. Once we funded, we record all the documents, and then about 30 days later, we issue that policy. So that's pretty much your title essentials. That's what happens. What kind of questions do you guys have? None? Okay. Well, thank you for joining us.
Thank you, Latra.
I have one question real quick.
And I do too after him.
Is there any variation for VA? I'm trying to recall. I've done this a long time, but is there any variation in the title process or costs for a VA buyer versus FHA?
So VA has VA allowables for the costs that can be charged. Typically that applies a lot to the lender side of the transaction. But as far as the processing part, that does not change. So we still have all the same moving parts that we have to get done.
Okay.
My question is, there was a lot of information. I was wondering if this got recorded, if we can like watch it again, because it was like really fast.
Absolutely.
Nicole's the boss on that.
Yeah. We will have slides and recordings available. So if you'll touch base with your TNT rep this afternoon, we'll make sure that you get a copy of either or both of those.
Okay. All right.
So
All right.
I had a question real quick. If do you have to have, like, so say you have a you know, husband and wife are selling a house, do they both have to sign the T-47? Like,
That's a really good question. And let's break it up into contractual obligation versus what we need to be able to issue the title policy. So where I see mistakes happen as far as the contract requirements is only one person signs the T-47 or it's not notarized. And technically that makes it an incomplete affidavit then. So then you have that gotcha provision in the contract that says they failed to deliver a T-47 so the buyer can order a new one at the seller's expense. And I have seen that getting used very often lately. So I say both of your people need to sign it.
okay,
For our purposes, we get one at closing. So we're not the ones really policing that. But you as the agents want to make sure you're satisfying that contractual requirement.
okay. And then my next question was, there's, after the CD, you have 3 days to review it, right? Is that always the case?
So if it's a residential transaction that falls under the TRID guidelines, then your clients should be getting them 3 days prior so that they have that review period.
Okay.
If you have, there are a couple exceptions. If somebody is buying and it's a reverse mortgage purchase, then they still get the old HUD statement. And so you won't see it on those.
Okay, gotcha.
Yes. Okay, I have a quick question. This is a listing that I almost got. I didn't, and I could get in the future, but there's something, a shed in the back. It's in downtown Austin on the east side. So this house is like 90 years old. And I noticed that there's a shed in the backyard that is actually really connected to, it's a 1-unit shed that is connected to the neighbor in the back. So it's like a building, and I guess there's a wall right where the fence should be. And
Okay.
So 2 neighbors share the shed, you know, right where the fence, does that make sense? Right where the fence is? So it's like 1 unit, but 2 different people are sharing the unit.
So it
what
crosses over the
happens?
boundary line of the property.
What was that?
So it crosses the boundary line of the property and 2 adjoining neighbors are using it.
Yes, it's basically 1 unit and 2 different households are using the same shed.
Okay.
What happens in that situation when you're trying to list the house like that? Because
Good
it seems to me like it should be kind of torn down, right? Because the new owner could have problems.
Well, that's an option. There are a couple of things that you can do, and it kind of depends on the parties involved in the transaction. So if we see that on a survey, we're going to say we want to make that a Schedule B exception because it's something that we know about and it's something I don't want to cover going forward. So if your buyer says, that's fine, I'll accept the risk, then it's okay. And we've accepted to it and they know that they would be the ones to have to remediate it if there were any issues. If your buyer says, well, I'm not really comfortable with that, so I want to make sure that I maintain my right to access it because I don't know what the other neighbor is going to do, then there are some documents we could prepare. One's called a license agreement or a use easement. So we could create something through closing that protects your buyer's right to be able to access that. Or the third option is your buyer could object to that issue and require removal prior to closing.
Okay. And what happens if you're going to list a home and it has a lien on it? Can that lien be paid at closing, or how do people pay the liens, I guess, or how does that work?
Yeah, so that's where we work with your clients. So we call and get a payoff statement and we put it on the closing statement, and we do pay the liens from closing so that we can reduce what they would get. So if your client has a $500,000 house and they owe $350,000 to Chase, we take those funds at closing, send the money to Chase, and then give the rest after closing costs to your seller.
Okay. So, but that would be a lien, I guess a lien like, say, a mechanic's lien or something like that. Those get paid at closing also?
Yep, we handle all of that because so that'll show up on your Schedule C, which are the requirements to get to closing. And that's where we work with the seller to find out who is owed the money, get a payoff statement from them. And we want to make sure that all those liens are paid also because we're issuing a title policy to the buyer. So the buyer wants to make sure they're paid. We want to make sure they're paid, and we're not going to close until they are.
Okay, thank you so much for answering all those questions.
Sure. Anything else?
Yeah, I have one. If one person buys a house and while they're single and then they get married and they're living in the house as a couple, but the property does not have the wife's, let's say the husband buys it, doesn't have the wife's name in the property records, they both should still have to sign, right? And that's not something that we would know from looking at property records.
Correct. Yeah. So when you guys are taking listings, you kind of have to play a little detective work, and you need to ask questions like, when you purchased this property, were you married or single? Have you married since? Because that's the only way you're going to be able to get them on the contract. And particularly when you're selling a homestead property, even if I buy a house as single and then I get married and now my husband and I live in the property, I don't have the legal right to sell the property on my own anymore because homestead protection comes in Texas. So my husband has to participate now. So he needs to be on that contract.
What about, this is an off question, I don't know if you can answer it, but what would be the process to get the names changed on the property records so that it reflected both of them?
So we see that happen a couple of ways. The easiest thing to do really is for the person who took title in the beginning to deed to themselves and the spouse, and then that would put the spouse in title.
Say that again?
So if I bought a piece of property before I was married and now I've married, I can sign a warranty deed from myself into myself and my husband, and that would vest both of us in title.
Okay. And just go to a title company to do that?
Sure. Yeah.
Okay. Thank
And
you.
by a title company, I mean us.
Oh, yeah. Got it. Absolutely. Thank you.
This is a question that I've always wondered. Do the title companies actually have a full-time attorney there on staff, or are y'all just in your own office and then they call y'all? I didn't know if there was always one there. I always wondered.
Yeah, so everybody does it slightly different. I'm general counsel for Texas National Title, so my full-time job is running our company and then also handling all the legal side stuff. So the difference for a company that has in-house counsel like we do versus one who doesn't have their own, anytime my escrow teams have a question or they're not sure how to proceed with something, or you guys have questions about how this affects your transaction, you guys just call me, and I put my cell phone number out there everywhere. I'll give it to you guys if you want. And not only can I give you the legal implications of what has to happen, but I also have the ability to get in your file and just make the decisions versus an attorney who says, well, we think, and then you still have local management that has to decide if they're comfortable with that or not. We just wrap it up all in one package, and it makes it a lot easier because there's not competing interests on it.
Okay, thank you.
What else?
I have a question, and it's kind of like a personal question, because it's like for me. So my name was misspelled on the title, and it's just one letter. Should I go ahead and request a change?
We can do that, or we could also do what's called a statutory correction affidavit to have you sign. Is your name something that is common where that could be easily confused, or is it more like mine where there's probably only one of us?
No, it's very common. My name is Diana, but like instead of an A, the last A, it was an E.
Ah, I got it. Okay. Yeah. So what we could do for you is what's called a statutory correction affidavit. And we basically just have you sign the affidavit to say my name was incorrectly stated as Diane. My actual name is Diana. We record that of record, and that'll fill that gap for you.
Oh, okay. All right. Well, thank you.
I have a question as well.
Okay.
Oh, I just didn't know if you could hear me. Okay, so one of my clients bought a house just under his name about 3 years ago. And then he got married but his wife is not a citizen of the United States, but she's now on the title.
Okay.
So if they want to sell the house, what do we need to do?
Good question. So did he deed her an interest in the property?
Yes.
Okay. So now you're going to be dealing with the FIRPTA Act, which is Foreign Investment in Real Property. So as an owner, when you're a foreign seller, there is a certain percentage that we're required to hold from the transaction and send to the IRS.
Mm-hmm.
It can be 10%. It could also be 15%. What kind of sales price are you working in?
Around 210.
Okay, good. That's good. So there is an exception to having to send that money to $300,000 and under. If it's under $300,000 and your buyer is going to occupy the property, then we don't have to do the remittance. And so
Okay.
you do have to go to the buyer and say, are you willing to sign this affidavit that says you're going to occupy? But if they will sign it, then we don't have to do any withholding. If
Okay.
they won't sign it, then we have to withhold 10% of the sales price. But in this case, we would do 50% of the sales price, then the 10% of it.
Okay. Is there anything special that we need to say or do in the listing or notify the buyer that this is the way it works, or how does that?
Well, I think something that you could take into consideration before you agree to accept an offer is having the conversation to ask them if they'd be willing to sign the affidavit. And if you're working with us, if the listing is going to come to us, we can give you that affidavit prior to closing, or prior to contract even. So you can
Okay.
give it to them and say, would you be willing to sign this? Especially if you're in a multiple offer situation, that might make a decision on which contract you accept.
Okay. And because she's on the deed, she has to be listed as a seller on the contract, correct?
Correct, yes.
Okay. Thank you.
Okay. So it's on the record. My cell phone number is 512-317-3646 in case you guys need it. My email address is Latra, Latra @texasnationaltitle.com. And y'all are welcome to send me questions that you have. You know, I can't really give you legal advice necessarily, but I can tell you what I see. And certainly if it's tied to one of our transactions, I can talk to you about what we could or could not do with something.
Thank you, Latra.
All
Thank you.
right, bye guys.
Thank you so much.
Bye-bye.
Bye-bye.
Thank you.